reflect on.
Mr Chairman.
The Honourable David Parker.
Mr Chairman, I want to just follow on from my colleague, the Honourable Ruth Dyson's comments. Canterburyans aren't just losing the right to vote, they're losing appeal rights. Because one of the provisions of the existing legislation that was passed in 2010 was to deny Canterburyans the right to appeal regional plans and also changes to water conservation orders. Normally, those processes carry with them appeal rights to the Environment Court. Now, I can understand at one level the national government wanting to sort out the regional water plan in Canterbury. Now, I don't think that justified the abolition of the regional council back in 2010. But given that that was the government's intent, I can understand their desire to sort out the water plan. But what I can't understand is 3 years after that, why they need to retain the right to change that plan without appeal rights to the Environment Court. It's outrageous that not only have Canterburyans lost the right to elect their councillors, they've lost the right that New Zealanders have in every other part of the country to appeal provisions and plans that they disagree with to the Environment Court. I see with some suspicion that in Part 2 we have the promise that the responsible ministers must begin a review of ECAN on 1 March 2014, and then it says that the review must cover, amongst other things, ECAN's powers and functions under Part 3. It worries me that we are going to see through that review process new proposals which we're not yet aware of, which may, for example, forever take away the appeal rights on plan provisions in respect of the regional plan of Environment Canterbury. It may also see the abolition of Environment Canterbury and the merger of it with the Christchurch City Council. Now, neither of those things have been acknowledged by the government as yet, but you wait. You wait. I think, well, not you, Mr Chairman, wait. We should wait, because I am, for one, suspicious that there is an ulterior motive here, because I cannot understand why else the government would breach its promise of 3 years ago. Well, I think the ulterior motives are the reorganisation of the councils in Canterbury to a vast degree, the effective subjugation of those interested in environmental outcomes in the rivers of Canterbury, having their interests subjugated to the more powerful interests of some people who don't want to do enough to improve water quality in the region, or want to abstract more water from those lowland rivers particularly than is sustainable. So, Mr Chairman, I think that this extension, together with these powers that are talked about being reviewed in respect of the powers and functions of ECAN under Part 3, as well as looking at the membership of ECAN, again code for looking at whether they should bring all of these bodies together, portends some future changes for Canterbury that I think will not suit Canterbury well in the long run. Mr Chairman, can I also endorse the comments of Ruth Dyson in respect of conservation orders? Conservation orders only apply to outstanding water bodies. There is only about 10 conservation orders in New Zealand. There's 2 or 3 in Canterbury. I can't remember which. Is the Ahuriri within this catchment? I think, is the Ahuriri within this, or is it the Otago Regional Council? I'm not sure. I think it's Canterbury. We've got the Rangitata. Now, the Waitaki doesn't have a conservation order on it. You need to understand what conservation orders. It's the Rangitata, the Ahuriri and the Rakaia. I think they're the main rivers in the Canterbury region that have conservation orders. The Rakaia is the first conservation order that was granted in New Zealand. Went all the way to the Court of Appeal. There were scraps between all of the people who had competing obligations, competing claims to it, and I actually remember it well because I was a junior in the case before the Planning Tribunal. That and the other conservation orders that are there are precious. It's very, very hard to get a conservation order to protect a river. These few rivers that we have protected with conservation orders are listed and have rules for the protection, Mr. Chairman. These few rivers that have conservation orders in the country have special protections that attach to them that put them beyond the control of the regional council. And that's because after this very thorough process, which starts with the minister having to be convinced that there's a real issue to be looked at, followed by a first hearing by a panel that's appointed by the minister, followed by appeals to the Environment Court, and the Environment Court eventually makes a recommendation, and then the government of the day chooses whether or not it implements that by way of a statutory regulation, which then has force against the regional council. And these few rivers that we have in New Zealand that have been identified as having outstanding characteristics are truly precious. They really are truly precious. By and large, most of them rise out of our national parks and are quite high volume rivers, but they nonetheless, these are precious rivers both for the aquatic environment that is maintained through those river flows, for fish and for natural, for the biota and for the morphology of the river that's maintained by decent water flows and these braided rivers, which in turn protects bird habitat and other things. Mr. Chairman, these rivers are absolutely precious. And this legislation, actually you still haven't heard the message. These are precious. And they should be preserved for New Zealanders and put beyond the ability of regional councils to modify them. And this legislation alters the status quo of those conservation orders and puts them within the jurisdiction of ECAN without any appeal rights to any Environment Court or anything like that to change. And it is wrong, it is unprincipled, and it puts at risk these precious rivers. So, Mr. Chairman, the Labour Party, for those reasons and others that have been covered by my colleagues, wants the Minister to explain why it is that it's necessary to strip our rivers in the Canterbury region that are protected by conservation orders from the legislation which protects them elsewhere in the country.
John Hayes.
Mr. Chair, I move that the question be now put.
I call Eugenie Sage.
Thank you, Mr. Chair. The silence from the government